Hello, welcome to this webinar from 42 Bedford Row. This is part of our series of talks aimed at the employment law, although this particular talk is actually for employment witnesses who are likely to appear at an employment tribunal. It's called How to Help Your Barrister Win at Employment Tribunal. My talk really falls into four different sections, which are all beginning with P. So they are preparation, pointers, presentation, and precision. So the first is preparation. And the first thing I want to cover is your statement. You'll hopefully have the assistance of a solicitor or a barrister to help you prepare your statement. But it's quite important that you must ensure that all your relevant evidence is included in your statement. Relevant evidence in terms of the issues list which the tribunal is considering. Bear in mind that employment tribunals don't listen to you read your statement out. They read the statement privately, so you don't get any chance to elaborate at the hearing on things that you may have missed out or thought of since you prepared your statement. Nor is your barrister able to ask any additional questions of you at the start of your evidence. And the barrister only has a very limited opportunity to re-examine you at the end of your evidence. They are only able to re-examine you to clarify matters that arise during your cross-examination, which is your questioning by the other side. So it's really important that your witness statement is comprehensive and covers all the aspects of evidence that are relevant and which you want to cover. Then, in terms of preparing for the actual hearing itself, do this in advance, ideally a few days before the hearing. So the first thing is to make sure that you read your witness statement a couple of days before the hearing and to know it inside out. Also, have a look at the documents that you refer to in your statement. That statement should be paginated, and hopefully you'll be given a copy by your solicitor or your barrister of the document bundle, the hearing bundle, which will be paginated and should be cross-referred to by page number in your witness statement. Do have a look at those documents that are referred to in your statement. You don't need to read the entire bundle, but do have a look at the particular documents you refer to. The reason that it's important to look at those is because you may well be questioned about what happened at, say, a meeting, and obviously the minute of that meeting is much more likely to be accurate than your memory because it's contemporaneous and it was taken at the time. It avoids you unnecessarily contradicting yourself or looking like an unreliable witness purely just because you couldn't remember what was in there. So if you can actually check your minute or the minutes that were taken at a meeting where you were present, that's a far more reliable account, as I say, of the meeting. Do also have a look at the other side's statements to check where they refer to evidence that you are evidence of events that you're dealing with. It's good to know what they're saying because you will then have a good clue of what the other side or the other side's witnesses are likely to be saying about particular events, and it will help you understand the likely line of questioning that your cross-examination will take. You're not expected to memorise documents or to know them word for word, but do at least know of their existence so that if you are asked about something, you can say, oh, can I please look at the minutes of this meeting? And then your barrister or somebody else, such as the judge, may well interject and say, well, it's at page 85 or whatever. Do make a note when you're looking at these documents in advance to prepare, if there's something in a minute which is fundamentally different or wrong, that you believe it's been inaccurately recorded in the minute, do just flag that up to your barrister so that they have some warning of the fact that these notes, which are generally taken as being accurate because they're contemporaneous, that it's good for the barrister to know if actually there is a disagreement, and they can prepare any groundwork in terms of asking you about your recollection and how your recollection of what happened differs from the written minute. Finally, in terms of preparation, just get a good night's sleep. It's obviously quite a tiring process, and if you are in a good, well-rested frame of mind, you're much more likely to be more settled, more confident witness. So the second P is pointers. And what I mean by this is pointers that you can communicate to your barrister in advance of the hearing, but actually not just in advance of the hearing, but actually at the hearing itself. So it's helpful points that will assist your barrister. You'll have seen the other side's statements dealing with events in which you're involved. Now, your barrister will have read those, and so your barrister will be aware of that content. But sometimes there's information which only you, as somebody who works at the organisation, only you will know. Your barrister may not necessarily know, or may not have been aware of something that is quite key and quite relevant. So if there is that extra information which your barrister wouldn't know, and you think that it's not something that they would appreciate from looking at the claim form, the defence, and all the different statements, then please do flag that up to your barrister. The best way of doing this is probably just to jot this down in an email somewhere. So say paragraph X of witness C statement, I'd just like you to know this information, and then send that in the various bullet points to either to your barrister directly, or if you have a solicitor, to communicate that through your solicitor. So then your barrister, when they are preparing their questioning, they will see that information and be assisted by that. It's also, pointers is also something you can give to your barrister during the hearing itself. So it's good to take a post-it notepad, jot down any points that occur to you if you're listening to the other side's evidence. What I would say is, though, don't be constantly passing up notes. It's a question of balance, because it can be a bit overwhelming for your barrister if they're trying in full flow to cross-examine and they are constantly being passed notes, which is quite distracting. But if there is some important information that you think they won't know, but that you know because of your unique knowledge and your unique position in the organisation, then please do jot that down, make it legible, make it as brief as you can, and then hopefully the barrister will understand the point you're trying to make. If they don't, they may well turn around and just have a brief sort of whisper in your ear for 5 seconds or so to just clarify what it is, the point that you're making. Having said that, in pandemic times, whether that is possible with social distancing, I'm not sure. So it may be that really all your communications have to be quite arm's length in terms of passing notes and so on, or you maybe have to wait till a break before you can speak to your barrister. So the third P of this talk is presentation. And that is really about how you present yourself to the tribunal. Now, usually you would have had the chance to listen to the other parties, the other side's witnesses, and before you give evidence yourself. But that isn't necessarily going to be possible during this pandemic. And that's because the tribunals, understandably, are trying to keep the number of people in the tribunal room to an absolute minimum. And so it may well be the case that the only people allowed in the tribunal room are the judges, 3 or 1, the 2 legal representatives, the party, and then the witness, to try and keep the number of people to about 6 in the room. So The disadvantage, of course, of you not being able to hear the other side's witnesses' evidence is that you won't know exactly what's happened. So hopefully your counsel, before you get on the stand, can actually brief you on anything that is relevant to your evidence, so that you can be questioned just briefly on a really fundamental point of disagreement. As I said, it's generally the case that it's very, very limited what your barrister can ask you, because you're their witness and all your relevant evidence is supposed to be in your statement. But there are some limited exceptions to that, and if there's something fundamentally that you disagree with, which has only come up in questioning from one of the witnesses, the other witness's evidence, then it may be possible for your barrister to ask you a question about that. But as I say, if you are able to have a chat with your barrister before you go on the witness stand, or if, for instance, you are able to get a written note of any evidence that's been given which is relevant to you, that is often very helpful. And I certainly, when I'm keeping a note, I type a note generally as I go of the evidence, and I will usually get that printed out and send that also to my witnesses if it's of relevance to them before they give evidence. Second bullet point: dress smartly. You obviously want to make a good impression to the tribunal. You'll be asked which holy book, if you are religious, you'll want to swear on, or you can affirm if you're not religious, and you will stand up at the start of your evidence just to swear or affirm before you sit down. And then, as I say, your witness statement has been read. Your barrister will just briefly take you through to confirm that the contents of your statement are true to the best of your knowledge and belief, but then essentially it goes straight into being questioned or cross-examined by the other side. So it can be a bit intimidating. So, just be aware that that is the usual process. And unfortunately, you don't have the chance to read your witness statement out loud or to settle in that way. Normally water will be provided by the tribunal in jugs and glasses, but unfortunately in pandemic times that little perk is gone, as it were, being called a perk. So do take your own water bottle, because otherwise it's very, very common during evidence for a witness to sort of dry up because they've got a dry throat, and so do take water. You're not allowed to take in anything else though, such as coffee or fizzy drinks. It's only a bottle of water. In pandemic times, whereas ordinarily there would be a complete set of the witness statements on the table and one bundle, my experience during the pandemic has been that witnesses are asked to bring their own clean copy of their statement, just so that to try and minimise handling of documents that have been in contact with other people. So but probably only applies to your statement. Just bring a clean copy of your statement if you can. In terms of the bundle of documents that is also used, at one point tribunals asked if each witness could bring their own hearing bundle, but I think that has really fallen out of favour. It's just not really practical, particularly when often the bundles are hundreds and hundreds of pages thick, and if you have, for instance, 8 witnesses in a multi-day case, you can't really all bring hundreds of pages of documents along. So generally there's just the one witness bundle on the witness table which is used, and then gloves and sanitizer are often provided too. In terms of how you address the judges, it'll be either one judge or 3 judges, depending upon the sort of case that is being heard. But if it is 3 judges, only the middle judge is a lawyer. The other 2 are people with significant industrial experience. So one will be from a employee representative background, such as trade union representative experience, or and the other wing member will be somebody who's from a management background. So it's a very balanced panel, but as I say, only the middle judge is legally qualified. Address them as sir or madam as applicable. Do note that proceedings in tribunals are not recorded, so there's a common misconception that there's an audio recording running, but that isn't the case. The only part of the proceedings that are audio recorded are when the judge is giving a decision, reading out a judgment, but the actual giving of evidence and the ordinary directions and the housekeeping matters, that is not recorded. So the key thing is that what you say has to be noted down by the panel. They'll either type it or they'll handwrite it. So do be aware of that. Be aware that you don't speak so fast that they can't take a note of it, because otherwise it will just get lost. And also, yeah, you don't speak too fast, and just give them time to record the evidence. Also, if you don't speak up loudly enough, again, that'll just be lost in the ether, and you may as well not have said it. So do feel free to address the judges when you're being questioned, rather than addressing directly the questioner. That's quite usual to do that, and you may also find that that is a way of perhaps slightly distancing yourself from the questioner, because when you're being questioned, cross-examined, it's very likely that the person cross-examining you is going to be trying to push you, pressure you, pile on the questions and make you quite flummoxed. So quite a good way of trying to distance yourself is to turn physically to the tribunal and address your answers to the tribunal, and that's perfectly legitimate, perfectly fine. So the fourth and final P in my talk is P for precision, and this is to do with how you answer the questions in the tribunal proceedings. Try and keep your answers short, as a tendency to ramble can look like you're trying to avoid a difficult question. You should also try and avoid making speeches. It's a very, very common trait for a witness to just go off on a narrative background because they have so much to say and they feel very, very strongly, very passionately about the matter, but it can just irritate the judges and also look quite evasive. So generally try and stick to either yes, no, or don't know. Usually questions can be answered in one of those three ways. Only elaborate on your answer if you think that the answer yes, no, or don't know is positively misleading. So if it's absolutely crucial to get in some context so that the tribunal can understand your answer, then fine, add that, but be sparing in how much extra stuff you add to your answer. Be aware that the person questioning you may well elaborate, and also the judges can also ask questions after you've been cross-examined. And furthermore, your own barrister also has a limited opportunity to re-examine you after your evidence to just clarify any confusion that's arisen, or to try and expand a little further on points that they think would be helpful to expand upon based upon the answers you've given during questioning. Try not to ask questions when you're giving your evidence. Try not to ask questions back to the questioner, however tempting that may be. It's quite common to hear witnesses ask rhetorical questions such as, well, how would you like being treated like that? Or, well, you don't really know what that person's like, do you? If you did, you'd understand. So, and it's very tempting to do that, but it actually just annoys the tribunal, and also it's not really your role. Your role is there to answer questions, not to ask them. So do resist that urge. If the question is confusing, for instance, sometimes, and we all sometimes fall into the bad habit of this, a question should just be asking one proposition, but sometimes the questioner may be asking this essentially two or more questions rolled up into one question. And that, of course, is very confusing, and it means that you can't answer it as either yes, no, or don't know. So if that happens, well, your barrister may well step in anyway to say, well, that's a confusing question. But if you do find it confusing, just say, I'm sorry, I don't understand. Can you repeat that? Or can you break that down? Because there seems to be more than one question there. That's absolutely fine. That won't look evasive because the tribunal themselves will be able to see, will have been able to hear that that question is actually quite confusing. So they'll be making a note of the question as well, in addition to any answer that you might give. Finally, try not to be a lawyer. I know that sounds a bit odd, but essentially your role is to answer questions rather than to make representations or to make argument about why your case is better. So sometimes you have witnesses who are trying to be a little bit clever and effectively start making the sorts of arguments that your barrister should be making at the end of the case in final closing argument. So I've heard witnesses say things like, well, I think you'll find there's an inconsistency between what the earlier witness said and this document. That sort of thing. Again, it looks a bit clever, and it won't really endear you to the tribunal, because your role is to be really just straight down the line, just quite straightforward and answer the question. Or if you find the question confusing, you should just say so. But don't make submissions. Don't make arguments or try and adopt the role that your barrister should be taking when they make their closing arguments at the end of the case. Anyway, so those are the four P's to remember if you are an employment tribunal witness. I hope that has been of some practical help and of assistance in helping you to understand what happens during the case. Oh, just one final matter actually, which is that, of course, when you're giving evidence, there will be various breaks in the middle of giving evidence, but effectively you're sent to purdah during your evidence, which means that whilst you're in the process of giving evidence, you must not talk to anybody else about the case at all. So that includes the barrister, other witnesses on your side, your family members, your friends. It's just essentially a matter that is absolutely essential to prevent your evidence being influenced or changed by something that is said to you during you giving evidence. But once you're off the witness table, that's fine. You can then discuss it all you like, but not whilst you're giving evidence, and that includes over lunchtimes and so on. So if you're having a break, maybe even extended break, possibly even a weekend, it's often just best to just distance yourself physically from anybody involved in a case, so as not to overhear conversations or speak to anybody about the case, which is it's just not something that's good to do. Anyway, so that is that's my talk concluded. So I hope that's of help. Thank you.
Hello, everybody. By the wonders of video technology, I seem to have got a haircut. So now is a chance to answer some questions that have been coming in on the Q&A, and yes, some very good questions. So the first two questions from Stuart and Sue Apps are essentially a very similar sort of question, and that is, so Stuart asks, if the tribunal are limiting people into the room, be that a physical or remote room, until witnesses are giving evidence themselves, doesn't that potentially unfairly impact the party not giving evidence? For example, when being cross-examined, a witness states something that an opposing witness would recognise as untrue and be able to inform counsel as such. This might be a matter not immediately within counsel's knowledge, that comes out of the blue. How do you deal with this? And Sue asks a very similar question on a very similar theme, which is that when a hearing is remote, how can the witness give the information suggested to the barrister because you can't pass notes? It's right that the pandemic has thrown up extra challenges. I mean, what I would say is that generally, if the matter is important, it's almost certainly been covered in the witness statements because it's a key factual issue. So the great likelihood is that you'll already know your position as a witness on a particular issue, on the important issues. And so it's likely that they will already know that and be able to cross-examine the witness that said something different based upon what your barrister has already seen from your statement and from the pleadings. But it's certainly right, there may sometimes be matters which still nevertheless arise. And what I would say is that it's quite good if, for instance, you're doing a remote hearing and you're all in different locations and you're doing the hearing by CVP, i.e. by the cloud video platform or something similar, an online video platform. It's quite good if you're able to, before the hearing, to set up some means of communication well away from the actual computer screen. So, for instance, setting up a WhatsApp group or something, if your barrister is willing to do that, or to email is another possibility, but often the only difficulty is that your barrister, if they're concentrating on screen and that's where they would be accessing their email, they may not be entirely, they may not be sort of wanting to go into their email account and see that. So something that's a more, another way that's completely away from the computer, another way of communicating like WhatsApp would be better, so that the witnesses can maybe communicate with counsel whilst the other witnesses are giving evidence and say, that's just completely untrue, please can you put it. Sorry, I've just noticed that my video is apparently not working. I think it's working again now. Yes, it's working, yes. So there will be quite regular breaks during the evidence, and it may well be that you can communicate with your barrister during that time, whether by WhatsApp or some other form, because obviously it's quite difficult to actually come to put something or to send something to your barrister whilst they are mid cross-examination. That is very difficult, but there will be regular breaks. There's usually at least one, if not two breaks during a half-day session. The other thing is that your barrister will probably be aware, if they're doing their job correctly, they should probably be aware that if an opposing witness says something which is important, your barrister should probably be aware that they will need to communicate with you as a witness to see what you say about that. So your barrister may well be saying to the tribunal, this is an important matter that's come up in this witness's evidence. I need to take instructions on this point because the witness isn't here to be able to speak to me directly. So can I please have a 5-minute break to just speak to my witness that might illuminate this matter. So that again is something that your barrister should be doing, hopefully, if they are aware of the issues in the case. The other thing is just really in terms of actual physical attendance, although it is right that tribunals are very much trying to limit the attendance of other people in the room other than the witness. It can't be a hard and fast rule. And of course, tribunal hearings are supposed to be public hearings. So if somebody insists on physically attending in the tribunal room, to be honest, I don't really see how the tribunal can absolutely forbid it. So if you think your evidence is, or it's crucial for you to hear a particular witness's evidence because you believe that they will be saying lots of things which you need to rebut. I think, say to your barrister, I think I really need to be in the tribunal room, and then your barrister can say, whilst we appreciate that the tribunal is trying to limit the attendance of unnecessary people, we think this is a necessary person to be in the tribunal room, and hopefully the tribunal should be able to make an exception to have you in the room, even if you may be quite socially distanced and sitting right at the back, far away from your barrister. So that's the other possibility, is really to try and get special permission or dispensation that you do be in the room, even with the limit on the number of people in the room. Is there a means of claiming witness expenses travel to the tribunal? Is a question that's just been asked. I believe that there is. I've not personally actually sort of seen the process of actually how that's happened, but I believe that there is a process for witnesses to claim expenses from the tribunal. I think you essentially go to the tribunal office and you make that claim and you just prove it by way of receipt. So yes, I believe that that can be done. Let me see if there's other questions. So Stuart asks a follow-up question about the witness attendance, which is if the witness doesn't sit because they're not allowed on the platform to view the CVP, how would they know to inform counsel? I don't think tribunals would ever prohibit anybody from being on the CVP. So CVP stands for Cloud Video Platform. So that's the online platform that's used to hold tribunal hearings, a bit like Zoom. I can't see any reason whereby a tribunal could prohibit the attendance, because these are supposed to be public hearings. So the reason for restricting physically with people in a tribunal room, if you're actually physically at London South or London Central or whichever tribunal, the reason for restricting that in pandemic times is obviously so that you don't spread infection. But I can't see any justification whatsoever for doing that in terms of witnesses or anybody that wants to attend. Any member of the public can attend, because there's just no reason to restrict that. So they would be allowed, any witness would be allowed on CVP. It's just a question of whether they physically have the time or have been able to attend or wish to attend. Let me see, it's just... Okay, I think that's all the questions. So unless any other questions come in, I think that that's the end of this webinar. So I hope that's been helpful. Yeah, there are lots of challenges still with the pandemic. I understand that they're rolling out a new online video platform called VHS, like the old video cassettes, but hopefully that will be a better video platform, because I don't know about you, but I've not found it a terribly efficient platform, and of course they're not allowed to use Zoom. Right, okay, thank you very much then. Thank you all, and have a good evening.